Preston. You're probably going to pivot a little bit, but give us some of your perspective. You've got a very unique perspective in this area, and what you've seen and are seeing.
Well, I have to admit that maybe, hopefully, like all of you, I was actually enjoying watching the discussion here because it is lively. And I just want to get a show of hands. How many folks have worked closely with the legal office of a college or university? Okay. So, and how many of us have worked with corporations, the Law Department of Corporation? And you know that there's a big difference sometimes between the two, right? So the college and university, oftentimes the law department is understaffed versus, you know, I was in the law department of GE, right? So we had a lot of lawyers, 1,000. And I think that kind of plays into some of the things that we're saying about colleges and universities here, right? And about the standards that are being developed. I think that most colleges and universities are not fully ready to enter into, or at least to enter into this territory in an informed way, as has been mentioned here. There are definitely issues about fairness. Understand, though, most of these law departments, from my experience, are deeply trained in privacy. That's one of the main things that they have to always remember. And so the fact that they're defaulting to privacy rights does not surprise me, right? And a lack of clear communications. Colleges and universities feel like they're in a catch-22, right? On one hand, you have OCR, you have the Department of Education, and in the case I'll describe for you shortly, you have the Department of Justice on one side, right? But on the other side, there are rights to students, and they want to make sure that students are treated fairly, and you know, sometimes the two just don't meet, right? So I came to this world of college and university, Title IX, but also / Clery work about now 3.5 years ago. My world was really representing companies in internal investigations, False Claims Act, corruption, things of that sort. And so my everyday was quite different than what's being described here. On the other hand, I did have the personal experience of, for example, when I was a kid, a neighbor being killed when she went off to college because she was raped and murdered. I also had the experience of, when I was in college, my freshman roommate committing abuse and getting literally dragged out of his room by 8 black guys about as big as me. And that was rough justice that, frankly, a lot of folks, and myself included, applauded, right? So what I had on in March of 2013 was two worlds colliding. And when I say that, I mean that I was called by a friend who knew the general counsel of a large college in Illinois that was in the news because the FBI, Department of Education, HUD, and Illinois State Police had taken over the police department, literally 54 agents, had shut down the campus's police department under allegations that the university had been violating the Clery Act. Now, all of us know what the Clery Act is. It's the law that requires us, universities, to tell the Department of Education and the outside world how many murders were there, right? How many rapes and other different types of crimes. I think it's about 7, maybe different now, but it was 7 during the pendency of our case. 15, okay, yeah. So the allegation was that the university had intentionally falsified its Clery reports in order to take part in Title IV funding. And the U.S. Attorney's Office and the Department of Justice had initially believed that that was a violation of the False Claims Act, right? So we're talking about two worlds colliding. you know, the facts about this university, oh, let me add also, this was a public university. It was a public university. As we found over time, having dealt with some of the experts that are on par with the folks on this panel, there had been no False Claims Act case brought under this theory until it was brought against our school. And you know, the fact of the matter is that the school didn't really know how to deal with it, all right? Because on one hand, it was trying to do the right thing and investigating issues and making sure that there was due process for both sides. But on the other hand, and so it kind of wore the white hat, but on the other hand, it was being accused in a criminal proceeding, right, of this, really this huge violation. The FBI came in on a grand jury warrant. So there was a grand jury that was impaneled in the Western District of Illinois. What I was told by a member of a former supervisor in the U.S. Attorney's Office after they had left is that when they looked at this school, they said, you know what, we've got to make an example of this school, right? So yeah, it was the first time ever brought, and maybe these are far-reaching charges, but we need to make an example of the school. To say that the university was ill-equipped to deal with this is probably an understatement. I think that they would really themselves say the same thing. You know, at the end of the day, of the six, the Department of Education gave the university two very large subpoenas. Now, I talked about, you know, the university wearing the white hat. Well, if you're wearing the white hat, sometimes you feel that it's your job to give the government whatever it wants, because after all, you're kind of part of the government too, right? You're a state university. You ought to give them everything. If you fight back, you're these criminal defendants, right? So what that meant then is that the department sent us on, frankly, a goose chase for about 8 months, and causing hundreds of thousands of dollars being spent in a review process, only at the end of which for the department to tell us, well, we really don't need that, right? After we had been, you know, dealing with this for some time. Again, you know, if you're in the shoes of having a public face and knowing that you're used to doing the right thing, it is hard to be a defendant, right? And that's certainly the experience that this school had. So, you know, I guess we talk about, like, are there special problems that a university would have in this context? That's certainly one of them. They're talking about internal. I'm talking about external. Mm-hmm. Now, what happened to our case, right? What happened to our case is we were able to argue that essentially the department was pursuing an implied certification theory under the False Claims Act. And under Seventh Circuit law at the time, and this would stand today in light of Escobar, that theory didn't work, right? Because the theory was that every time they submitted a clery report, every time that they asked, participated in Title IV, that they were somehow violating the False Claims Act. The U.S. Attorney's Office agreed with us that that's not a violation. Not only that, but we showed that our clery reports were right and that there had been no intended violation, and that to the extent that there were technical violations, of which every university has, that there was certainly nothing behind it. So I'll leave it with that. But that's a snippet, and so just to leave it with that, as Andrew said at the beginning, the department walked away in February of this year, or I should specify the U.S. Attorney's Office walked away in February of this year, because once the newspapers found out that the U.S. Attorney's Office was no longer pursuing the case, they reached out to the FBI and Department of Education. And even though the press had already confirmed with the U.S. Attorney's Office that the investigation was essentially over. The FBI and Department of Education said, not as far as we're concerned. Which is kind of unusual, seeing that the U.S. Attorney's Office was running the investigation in the first place. I will say that since that time, we haven't heard from the FBI or Department of Education, so it was over. I'll leave it with that.
Thanks, Preston. So we will turn next to Karen, who actually has a slide deck on some of the issues that she's going to be talking about.
Thank you, Andrew. Good afternoon, everybody. We've heard some pretty specific detail this afternoon about the state of affairs as to sexual abuse on campuses from various perspectives. I'm going to talk about something else. I'm going to talk about the anatomy of a scandal, because whatever views one may have with respect to the rights of the victim, the accused, due process, campus versus court, let's not lose sight of the fact that the reputation of a school is at stake, and as a deep pocket, a lot of money, and that these cases can be extremely sweeping and everlasting. Baylor is a case in point. Baylor has been in the news a lot this year. Indeed, just this week, a 60 Minutes expose exposed that the sex abuse that had been reported at the school was far worse than disclosed. What complicates things is that a school like Baylor, or a school like Florida State, with Jameis Winston, their Heisman Trophy winner and now quarterback for the Tampa Bay Buccaneers, or schools like Oregon or Tampa or Tulsa, have football programs that bring the schools a lot of money. And the perception that the schools are protecting their athletes at the expense of the victims. And when you have that, this means the school's conduct will be scrutinized far more carefully, the publicity more intense, the perception that the school turns a blind eye, and ultimately, using Brett's terms, the perfect storm for a Title IX issue. Baylor is a case in point. So I just want to talk about what happened there and what's going on to give you some perspective about how these things can truly spiral out of control. Quick chronology. There was a reported incident of sex abuse at Baylor in 2011. In the spring of 2012, a victim, I'll call her Tanya, reported a sexual assault to the Waco police. But the school police on campus did nothing. They didn't offer her an escort. They didn't offer security. They claimed that they didn't have to because the incident occurred off campus. The student went to the health center for counseling. She was told she had to wait and to be on a waiting list. So the same thing occurred with respect to academic counseling. She was the 5th person to report this victim to the police, and he was ultimately convicted of 2 counts of sexual abuse because of her complaint. Baylor was required under Title IX not only to investigate, but to offer these victims those services. They didn't even have a full-time Title IX coordinator at that time. They didn't get that till late 2014. And then then a 6th person came forward, and it was only then that that athlete was no longer allowed to play. He is now in jail for 20 years. During this period, another football player was accused of another rape. This time, the school did investigate and cleared him. The DA, however, convicted him in a court of law and noted that the Baylor investigation spoke to a 1940s mentality where there was no real understanding of how men and women actually engage in 2016, or at that time, 2013. After that, the Texas Monthly investigated that rape case and concluded, as to Baylor, willful ignorance of previous accusations, obfuscation of facts, and the fact that the coaches were well aware of the problem, but really did nothing. They also recognized that the Waco police and the college police had colluded on keeping a gang rape, the 2011 rape I talked about earlier, out of the press and, in fact, not on the statewide computer. In other words, the police report remained locked in the police station offices. Some facts worthy of mentioning. Baylor athletes make up 4% of the school's population, but they were named in half of the reports of abuse. Baylor is a Big 12 conference school that share $220 million of revenue with its conference rivals. So for Baylor, football is big business. But people started talking, and the winds of change began. Finally, after a groundswell of discussion and complaint, the school engaged outside counsel to investigate how the school was handling its sex abuse cases. After months of review and interviews, the law firm Pepper Hamilton came out with a blistering, and I mean blistering, report as to the conduct of the university. It said that it repeatedly and actively refused to report sexual abuse allegations, that when investigations did occur, a lot of times it was done simply by the people in the athletic department, speaking to the accusers or their families, that the administration itself was discouraging complaints, that the football team had its own system of discipline which insulated the players from proper disciplinary actions. And as I state on the slide, this constituted gross misconduct and fundamental failures as to the handling of assaults under Title IX. That report was issued in May. What's happened since? Well, the school has certainly apologized, and the Board of Regents shocked at the findings. They fired their head coach, Art Biles. They demoted, and then ultimately Ken Starr, the president, resigned. Yes, it's that Ken Starr, by the way. The report also made specific recommendations that the school adopted. But there's more. Only 1 week ago, the 60 Minutes expose discussed some of the significant findings of abuse that were far worse than reported. 17 female students reported against 19 football players since 2011. And this is a school that touts Christian values and prohibits sex. More importantly, the expose reported that Baylor's own Title IX coordinator, Patty Crawford, resigned that month, claiming discriminatory conduct against her because she was set up to fail and because she lacked the resources and independence to do her job, and that she had resistance from the highest levels of the school. In other words, a complete institutional failure. Lo and behold, she has filed her own Title IX lawsuit, and there are now 10 other people who have filed Title IX lawsuits. And on October 19th, the Department of Education commenced its own Title IX investigation of Baylor in light of Crawford's complaint. I guess the good news is that the football team is 6-1 this season. So what takeaways do we take from Baylor? By the way, I'm just going to pass through this. The report that was issued by the law firm gave 154 different recommendations to improve its Title IX protections. And these are some of the more general ones. I'm not going to take the time to read them, but they're really very fundamental. Okay, so what are our takeaways from the school? One, Baylor let its problem fester and grow. There's no reason that Tanya, the fifth victim, should ever have been assaulted. This should have been handled at its initial phase when you had your victim number one. By not taking action initially, they showed a deliberate indifference to the rights of others, for anyone who came thereafter. Two, they failed to have a full-time Title IX coordinator until 2014. That means they didn't effectively implement Title IX even after the OCR's Dear Colleague letter in 2011, and they failed to appreciate the national scope and high-profile examples of other institutions. They lacked the infrastructure and knowledge to effectively deal with their problem. In other words, they were late to the party. 3, they allowed and they indeed protected the coaches and the players and the brand. They failed to recognize, or they recognized but disregarded, that certain members of the athletic staff discouraged and created barriers to Title IX protection. The group was likened to a star chamber, and that's probably accurate, but you can see how dangerous that is. And the steps taken by the institution or the administration to try to fix that problem were grossly inadequate, especially when it was well known that gang rapes and dating violence was prevalent among the team. The 4th takeaway, if you're going to launch an investigation and release it as a defining moment at the school and a sea change in how they're going to handle their policies and procedures, you need to have your ducks in a row. I think it's very unfortunate that 5 months after that report and recommendation was released, journalists were able to produce the expose that we heard about this week. It called into question the integrity and the thoroughness of the initial investigation, and it effectively destroyed any of the goodwill the school might have gotten from releasing the report in the first place. Lastly, if you're in a crisis mode, and if the press is investigating you, and if you've amassed 10 Title IX complaints, which are now strong and viable, and handed to the victims in some respects, thanks to the commendable efforts of the school to make public the results of the investigation, the last thing you should do is make your Title IX coordinator your 11th plaintiff. We don't know the entire backstory here, but we know that the information that Ms. Crawford has relayed as to the institutional failures only exacerbate the situation. And here again, it's led to a formal investigation by the Department of Education. Just yesterday, Penn State was given a penalty of approximately $2.5 million by that group based on their investigation. The bottom line here is that for Baylor, this problem is just beginning. It's not likely to go away soon. The cost is impossible to predict. But I guess their football team is doing great. Thank you.